The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Access Television, the City of Oshkosh, the Oshkosh Cable Television Advisory Commission, or Time Warner Cable.
Hi everyone, welcome to Eye on Oshkosh. I'm Cheryl Hentz along with my co-host Dan Rylance. And on this edition we're very pleased to be joined by two professionals who are in the Fox Valley, and they are of different professional services, if you will, but they have come together with several other professionals in the area to form a collaborative, and we're going to be talking about that tonight. Jan Butterbrodt is to my left. She is a therapist or counselor, if you will. And we're also joined by Mark Schubert, who is a licensed attorney at law. Now, they, along with several other professionals, as I mentioned, are part of the Collaborative Professionals of Northeast Wisconsin, Inc. It's an organization of attorneys, mental health professionals, and financial advisors who provide dispute resolution services using the collaborative process to individuals and firms in Northeast Wisconsin. So welcome to both of you. We appreciate your being here, especially the day after a holiday. So
thank you for having us.
And we appreciate you, Jan, contacting us about your organization and both of you coming on to talk about it. Tell us a little bit about the collaborative to start with. How long has it been in existence? How did it get its start?
Okay, Mark, I'll defer that to you to give the history.
The collaborative process was actually invented by an attorney from the Twin Cities area, it's, Minneapolis or St. Paul, and he came up with the concept for the collaborative process in 1990. So it's really a very new process. It came to Wisconsin sometime after 2000 or 2001, and took a little bit longer to get to the Fox Valley. So we've been organized, I think, loosely as a group for several years, but finally we're able to incorporate as the practice group that you mentioned just last fall. So it's really a very new process.
Very new, okay. How many members do you have?
I believe we have somewhere between 15 and 20.
15
they're
and
all
20?
listed
Okay.
on our website, and it can change from month to month, but I believe there's 18, I think.
Okay, and that's a combination of mental health professionals, attorneys, and financial, is it financial counselors or financial planners?
I call them financial specialists because,
Okay.
and we happen to have one of the best in the Oshkosh area, and that is Benita Graf. And they have special training in helping couples uncouple and making those very difficult decisions as to what to do with the money.
Okay, all right. How did you all kind of come together?
Well, when the collaborative process was brought to Wisconsin, one of my associations was contacted, and that's the Wisconsin Association of Marriage and Family Therapists, believing that the mental health professionals, the trained and licensed marriage and family therapists, would be the association to contact because of specialized training, being aware of the difficulties in a relationship, and helping couples through the divorce process. And so when I first went to the trainings in the state of Wisconsin and looking around the auditorium, there were a number of us from all the different disciplines, whether attorneys, judges, guardian ad litems, financial specialists, marriage and family therapists. For most of us, we had a few gray hairs or a few wrinkles. In other words, we've been around for a while. And we've seen how the ending of a relationship can impact people. And certainly the children, and children caught in the middle. And so this was a kinder, gentler way for a couple to uncouple and still remain a family. And so that's why I embraced it. And I've seen couples go through this process where at the end of it, they still parent effectively together. They still put the children's interests as the most important thing, and they still can talk. And that isn't always the case for couples going through the divorce process.
Okay.
And when I say the uncoupling process, there's been an increase in cohabitation, meaning couples are not getting married. So this is a very important group that we have to pay attention to, because they're not part of the statistics for getting married, and they're not part of the divorce statistics. However, they have many of the same issues. For many of the couples, they have owned property, they have owned homes, they have mortgages together, they have children together. And so their issues are very much the same. And,
Okay.
need
I want
census.
to read something from your website, and then maybe you can kind of explain what this means. It says the collaborative process is a new form of dispute resolution in which the parties and their attorneys enter into a formal agreement not to submit any contested issues to a court for a contested decision, but rather to use a specialized, fundamentally non-adversarial process of negotiation to resolve all issues by agreement. And then it goes on to say that the collaborative process is a reasonable approach to dispute resolution founded on 3 basic principles. What are those principles?
I don't know if I can remember the exact language on the website, but it's a shared agreement not to go to court, a commitment on the part of all involved to seek a resolution that is the best that can be achieved for everyone under the circumstances, and a disqualification of the professionals that are involved in the event that the matter is not successful as a collaborative proceeding.
Now, what does that mean, a disqualification?
The essence of the collaborative process, and the thing that really makes it different than other forms of dispute resolution, is, as you mentioned in the quote, that it's really intended to be a non-adversarial approach to the resolution of legal disputes. It's been most commonly used for family law disputes like divorce cases and paternities and situations where people have children or property issues even though they might not be married, although it could be used for other kinds of disputes as well. But the essence of it is that it's a non-adversarial approach, and that's obviously fundamentally different from the approach that's taken in our traditional court system. There's nothing wrong with that approach, but oftentimes people, particularly in family law cases, find that the consequences of going through an adversarial process of dispute resolution are negative, that they're unwanted, that they can cause stress and conflict and trauma within the family that people have to live with after the case is resolved. The disqualification is an inherent part of what makes it possible for us to transform what is unavoidably an adversarial process in the court system into something that's non-adversarial. And the essence of it is that there is the shared commitment on the part of everyone involved that we're going to seek solutions that are win-win oriented. And in order for there to be a meaningful difference between that process and the traditional court system, there has to be a way to make it separate and distinct in a complete way. And so the way that we do that is by having a disqualification agreement. And what that means is that the parties aren't forever waiving the right to go back into the court system and to litigate their case if they wanted to do that. They always have the right to do that, but if they elect to do that, and they file what's called a notice of termination of the process, then both of the attorneys have to withdraw and both parties have to go out and retain new attorneys to represent them in litigation. Without having that, there's really nothing that separates the kind of process we're trying to use from the ordinary way that a case progresses through the court system, which is exactly what the parties are trying to avoid. So coming up with that approach and that concept was the thing that really was the fundamental element that allowed the inventor of the collaborative process, Stu Webb, to make this process truly effective.
Okay, all right.
Before this evening, I was reading your website and got the same thing that Cheryl did. And my wife was speaking over my shoulder, and she said, You know, I don't think that's a new process at all. She said, ask your guests about the Orthodox rabbis who for centuries have had a process that mirrors the collaborative process. It's called mediation or rabbinic rulings. Are either of you familiar with that older Jewish tradition?
I'm not. I'm
Okay.
sorry.
I'm not, I wasn't either, but you know, it's just funny how people read different things. She said, that's very old. Now, I'm sure there are some differences, but this was, I think, where a couple would go to the rabbi in a non-threatening, non-legal way, and he would mediate it. His decision could not be appealed, and that's how they settled some of these things in ancient times. So I just thought I would throw that out.
I'm not familiar with the particular tradition that you're talking about, but the process of mediation as an alternative
Right.
is something that has been available probably for several decades now. It's one of the first movements that gained particular notoriety in what we refer to as alternative dispute resolution. And collaborative process is just one example of an alternative dispute resolution technique.
How would you distinguish mediation from your collaborative? Is it one is more universal than the other, or fits, or how would you distinguish?
I oftentimes, when I'm meeting with a couple, I like to describe a continuum.
Okay.
And that continuum is when a couple has made that choice, a very difficult choice to uncouple, that there are some options out there. And one of them starts out as what I call the kitchen table, the pro se model, where they sit down and they begin to identify who will take what will we do around the decision making. Then as you're moving down the continuum, you can then go into mediation, where again you have a neutral party sitting down with that couple and really being a sounding board that each can tell their story and kind of helping them with that process. As you come down further down that line, again, Mark, jump in at any point, offers the collaborative process, where again the couple is still having a great amount of the ability to make their own decisions. However, now they have neutral parties who are giving them expert guidance and again pointing some things out. As you go further down that line, then you have attorney-assisted divorces, and then you have the litigation. As you come down that line, you're getting less and less say-so, you say, in the decision-making process. If you leave it up to the judge is going to make those decisions. I oftentimes, working with a couple, will say that we're utilizing the mediation techniques and the tools. But what helps with the collaborative process is you are having experts, trained professionals giving you guidance and direction. Whereas way down at this end, the pro se, in a study, 67% of the couples would have chosen something else. Had they known of something else, they just didn't want this end one. They did not want to go to a litigation model. And that's why I thank you for this opportunity that we could come and talk about this, because a lot of people don't know about it. They think there's only really two options. That is pro se or a litigation model, when in actuality there's a number of different options out there and available to them.
That helps explain that, and where mediation would be part of your process, but you have many more parts to your collaborative process than just mediation.
I think Jan did a great job of explaining the major points, and I maybe could just re-emphasize a little bit. The biggest difference between mediation and the collaborative process is that with the mediation approach, you're typically choosing a single person who's acting as a mediator.
Like the rabbi?
Right, like the rabbi, exactly. And that person is there to really help guide the process of negotiation, to help identify issues, to assist in terms of communication between the two parties, and to help them essentially negotiate the rapids to the point where you can reach a compromise. With the mediator has to be completely neutral. The mediator can't provide advice or assistance to either party. If the mediator loses his or her objectivity and neutrality, then they're not able to perform their function. The difference between that, which is a perfectly acceptable and great method for some people in some situations. There's nothing wrong with that. In fact, none of the options that Jan mentioned are always right or always best. It's a matter of matching up which one is going to best suit people's needs and circumstances. But the difference between mediation and collaborative family law is that in a collaborative family law context, both of the parties have an attorney that provides direct advice and assistance to them as they go through the process. And so if they need help in understanding the law or their legal rights, or assistance in terms of developing what's important to them or how they should approach an issue, they have that available to them. And that's something that I think a lot of people who would otherwise be very attracted to the concept of mediation would find that the collaborative process can in many cases be superior, because they have that direct, active advice and assistance as they go through.
And that's very important, because I am a trained mediator and have the honor of mediating in small claims court. And part of it is you are an ambassador of the process. You are a protector of that neutrality, and that's very important. And for most people coming in a small claims court, it typically is a landlord-renter dispute. It could be a medical facility and somebody hasn't paid their bill and trying to work out a plan or what have you. But in most of the situations, the people will not have contact with each other once they leave here. And so being that ambassador of the process and making sure that there's neutrality and both have the opportunity to tell their story and then, negotiate and mediate a settlement or an agreement, the people won't have contact with each other. And they'll leave here, and either on their drive home or a couple days later, they may not have gotten exactly what they wanted, but now they can put it to rest. Whereas in a relationship, they're still going to have contact with each other, especially if there's children involved. And so as Mark said, there's situations where they're going to need to have some guidance, some input from the experts to say, you might want to consider this or that. So, yeah.
Walk us through, folks, the process. Someone comes to you, whether it be an uncoupling, as we've kind of been talking about, say it's two roommates squabbling over, who knows, any kind of issue, a landlord-tenant situation, whatever the case may be. How does the process work? What's the first step? And kind of walk us through that, if you would.
Okay. If let's say a couple is coming through the mental health arena, many times couples will come in and want to save their marriage. We'll try to look at ways to improve their relationship. It also may be an opportunity for them to have a safe place to look at making that very difficult decision. And again, I always say, I will never make that decision to stay or go. That needs to be yours. You live with the consequences. But if that decision is made, then I will give them the names and the phone numbers of attorneys, give them the website, so that they can begin to gather information, factual information, because about this time they're getting stories from their friends, from their neighbors, from their coworkers. They're getting advice, and typically the people who are giving advice have a vested interest in how it will go. But I say this is a very difficult time of your life, and you're going to need to have factual information. And so then, again, referring them to the website, to attorneys to get that information. And so that's kind of the route if they come through a marriage and family therapist.
And if they have a dispute and their first point of contact is an attorney, most of the time the attorney will educate them about what the collaborative process is and the other options as we've discussed. It's really not my function, I don't believe, to tell someone the way that they should resolve their legal case. It's really their decision. And my focus is to empower them with the information about the options and the advantages and disadvantages of each of those options. If they express an interest in the collaborative process and they want to pursue that, then it's my function really to help educate them about what's going to be involved And usually what we would want to do is to have there be a collaborative attorney retained for the other person, their spouse or the person they have a dispute with. And as opposed to just immediately commencing formal legal procedures, which would be more common in the traditional system, we will usually try to coordinate voluntary meetings and whatever legal procedures, for example, that might need to be pursued, we'll try to do that in cooperation with each other. The process, the collaborative process itself is focused on four-way meetings, typically between both parties and both attorneys. And so it's not uncommon for us eventually then to set up an initial four-way meeting where we can begin the process of dispute resolution. So that's kind of a generalization about how we would start a case, if it's initiated through the attorneys.
How many meetings or how long of a process is this normally?
For divorce and family law cases, which is what we have the most experience with, at least to date, it can vary considerably, as you might imagine. I've had cases that have been resolved more than once with 2 meetings, which is very brief. I've had other cases where there have been more than 10. And it really has to do with how aggravated or how difficult the issues are and what resources we can bring to bear. The 2 parties and the 2 attorneys themselves are kind of the core group within the collaborative process. But one of the strengths of the collaborative process is that we can also include the other professionals, at least in a family law case that we've talked about, with mental health professionals who serve not in a therapeutic role. They're not there to provide therapy. What they're there to do is to help assist the parties in dealing with emotional or psychological or communication-related issues that might otherwise prevent them from participating effectively in the process.
Okay.
I think you said this earlier, Mark, but I just want to make this more clear. If the parties cannot agree, then they can dissolve and then they can go to more traditional ways, but the collaborative process at that point ceases, is that?
That's true, yes.
And they can appeal your decision if you come up with one, or is that right? I mean, you're not in a court, so they can't take it anywhere.
Yeah, see, by definition in a collaborative process, there is no decision.
Right.
All there is agreement.
All right.
And if people don't feel comfortable in terms of an agreement being the best we can achieve under the circumstances, then I would tell them as an attorney, then don't agree.
Right.
Okay. We can continue to work together until we can find that kind of agreement. Or in rare cases, people can elect to step outside of the collaborative process and go back to court.
Yeah, I probably used the wrong terms, but the point is that you can't go somewhere else, whatever happens. I mean, you can dissolve it, but you can't appeal it because, like you said, there's really no decision to appeal.
Right.
And that's what's, again, I think is so grand about the collaborative process, is that the couple are actively involved in generating the decisions and generating the agreement. And most of the time, if we can be part of that process of generating agreement, generating a decision, then we're more likely to adhere to it. We're more likely to accept it. And that's what's one of the neat things about it. Also, too, if as a marriage and family therapist, we don't do therapy. However, our skills and our training can be very helpful as what we call a collaborative coach. And what's unique about the Northeast Wisconsin collaborative group of professionals is mental health professionals have been utilized for evaluation. We will meet with the husband, we will meet with the wife first, in order to identify strengths, what they're going to be bringing to the process, maybe to identifying if there might be some issues, whether they be mental health issues, because again, depression goes hand in hand with difficulties in relationship, drug alcohol issues, a number of different things, and be able to offer some guidance in all of that. We're also working on in Northeast Wisconsin is developing what I call the family ambassador. It's been referred to as the family specialist. In Arizona, I think they have labeled it the wise one. In the state of Wisconsin, Dr. Ken Waldron has been working a great deal on the parent coordinator. That this would be a highly trained professional who would would help this family navigate these waters, along with the fact that this person would then be accessible. Their services would be accessible well after they're done with the divorce, so that this person could help them go through that first holiday, help them go through what would have been their anniversary date, help them go through major life transitions. Also be there as someone that the children can come to. And that many parents identify as something they're looking forward to, that they would have a contact person that they could bring the children to, and this person would meet with the children, kind of keep a thumb on the pulse. How are they doing? And monitoring them through the process and stuff. So it's kind of unique for our area.
In mediation, at least when you go through Winnebago County conflict resolution, those agreements are legally binding. Because this is something a little different, are the agreements that the parties reach with you all, are they legally binding also?
Once they're submitted to the court and adopted and approved as part of an order or a judgment, yes, they are, just as they would be in mediation or any other process.
And then what would happen, Mark, if for example, you know, the couple agrees, or, you know, whoever the two, we'll call them litigants for lack of a better word, the two parties.
Participants, maybe.
Participants, okay, there we go.
And that's where, again, sometimes it's terminology.
Sure.
There really is.
Okay.
Words are powerful.
Okay, so the two participants, thank you for wordsmithing that. They reach an agreement, they come to an understanding, their agreement is submitted to the court, something happens then, whatever it may be, and somebody defaults on that agreement. What happens then?
The first thing I would say in response to that is that there tends to be a lot less frequency of people having problems with a need to enforce or appeal or deal with issues after resolution of a collaborative case. And the reason's fairly straightforward. I mean, we're not dealing with a situation where an outcome has been imposed on people because of a judge's decision or because of the pressure of that environment and feeling forced into a settlement because it's the best of two very bad alternatives. So it doesn't happen nearly as often. That is true generally in terms of the research that's been done in the collaborative areas. It's also true in my experience. But if we did have a situation where someone didn't comply with an agreement that was adopted as a judgment or an order, the parties would still have the ability then to address that situation in the same way that they did with the resolution of the original issues, meaning that they could recommence the collaborative process if they needed to. They wouldn't have to, but they could. And that certainly is an option that we make clear to people is available, and that our help can be continuing in that sense. If they, for whatever reason, felt that they didn't want to do that, or that it would be better for them to proceed to enforce that judgment or order in the conventional fashion, they would have the ability to do that. There isn't anything less valid about the judgment or order in a collaborative case because it was resolved or created in that fashion. So there's no limitation in their rights in any sense.
Okay. Mediation, at least in Wisconsin, because our courts are so swamped, mediation is mandatory in, I think, just about all cases. This obviously is a little different. How do the courts view the collaborative process as opposed to mediation?
I think it's difficult to generalize about anything as large as the justice system, but overall I think most judges are understanding and supportive of the collaborative process. They recognize the intent behind the process and they're supportive of it. And I think most judges would recognize that cases that are collaborative end up far, far less often being the kind of problem cases that really clog up their calendar and take a lot of time and create difficulties for them scheduling and otherwise. So generally speaking, what I've seen is a lot of support from the judges and from the judicial branch.
Well, as a follow-up to that then, if a judge were to order mediation, as they so often do, then could this be a route that the parties could take? Or would they have to go to an actual mediator per se?
There are differences between mediation and the collaborative process, and I think it's important to understand that to really clarify. People could, meet with a collaborative attorney and really go through that, or another collaborative professional. The big difference in the context that you raised is that the collaborative process really isn't going to work unless both of the parties really genuinely want to do it and want to make that commitment and have sincere and valid reasons why they're motivated to pursue a difficult process like the collaborative process. I've seen in my own experience professionally that it's rewarding to proceed collaboratively, but it's not easy. Okay, you're pursuing an outcome that's win-win. That's good for both parties. And that requires that you be clear about what's important to you and that you be willing to really listen honestly and sincerely to what's important to the other person to try to achieve an outcome that's good for them as well. That's not always easy, especially when you're in the midst of a divorce or a custody dispute or something like that. That's probably the most challenging time of all to approach the resolution of an issue that way. So I don't think it would be a good idea at all, and nor have I ever heard of a judge ordering people to proceed collaboratively. If a judge ordered mediation or some other form of alternative dispute resolution, and the parties in the course of exploring that or thinking about that would discover that they want to elect to commit to proceeding collaboratively, that would be great. But the parties really both have to want to do it and to choose to do it in order for it to work properly.
Sure. But it would be, I guess my point then is, it would be an acceptable route for parties to take in a judge's eyes.
I believe so.
If he orders
I've never
mediation.
really had it posed quite that way, but I think a judge would accept that.
Okay.
Because as Mark said, most judges who are aware of this many of them will embrace it because it is a kinder, gentler way, and typically the parties are in agreement, and they're less likely to come back, and they're less likely to clog up the legal system. But as Mark said, that a key is that both are willing to participate. Now, having said that, in most situations, typically one wants out and one would give anything if they could make it work. So there's an issue of timing and an issue of pacing. Timing meaning that if one had their way, they would be done within like that. The other would give anything if they could hold their sweetie still in the relationship. So the collaborative process offers that vehicle, that arena, to help with that difference of timing and pacing, so that you're encouraging this person who wants out to be fully aware that this person isn't up to speed. That typically by the time the person's made that decision to get out, they really have emotionally exited that relationship maybe 2 years before that. And if we reel back the hands of time, we can be aware that maybe that relationship has had difficulty even before that. So they're so much further ahead. And for them to be aware that this person is back here and they've got to be kind of brought up to speed. And having the collaborative process, you're allowing for those differences. You're not imposing a date, a deadline on anybody, but you're honoring that they're at different places and stuff. So
I've been thinking the last few minutes, your spin, and I mean that positively, not negatively, it's a win-win situation. You don't have to go to court, less time consuming, but my billfold keeps hitting me a little bit and saying, but nothing is free. What is the fiscal note on this? How do the financial arrangements work with someone that would come in? Could you kind of go through that a little bit? Do you pay this group you have, or do they pay you individually in your expertise and your expertise? Could you kind of go through that a little bit?
oh, certainly.
Well, I guess I can start off. Basically, all attorneys working in divorce and family law in particular, because again, that's the most common place where we're using the collaborative process, we all have to work based on an hourly rate.
Okay.
Because there is no such thing as the average divorce. I mean,
Okay.
people's lives are all different.
Okay.
And there can be a tremendous variation in the amount of cost involved because the amount of work involved in one case versus the next varies a great deal. In my case, my hourly rate, I don't charge a different hourly rate for a collaborative case versus a traditional one. But as long as we are able to be careful on the front end and helping our clients make good choices about when it's appropriate to proceed collaboratively, experience consistently has shown that you're going to have less cost in a collaborative context. Even if you would make the decision to involve some of the other professionals that would be needed, which I would note that in our area, it's not mandatory. In other words, we bring in additional professionals as needed on a case-by-case basis, and that's not always true everywhere in the world or everywhere in the country, but it is true here. It's one of the innovations that we've kind of developed locally, and there have been a lot of them actually in Wisconsin and in Northeast Wisconsin in particular. The reason why the cost can be less is because the parties have a lot more control over what procedures are utilized, what resources are expended and for what purposes. And I could just give you a couple of examples. In a litigation context, the way that we resolve things is by means of either a settlement or a contested hearing or a trial. I mean, that's the way the process works. And it's very common in the traditional system for matters to be resolved by settlement, by agreement. There's no question about that. But oftentimes it doesn't happen until people feel the pressure of what the alternative is going to be if they don't give their agreement to whatever's been proposed, and that oftentimes is on the courthouse steps. Well, by that point, you've invested a lot of time and a lot of expense by having your attorney get ready and be prepared to have that hearing, whether it happens or not. And assuming that you go through with the hearing, it's not uncommon because of the congested court calendars and everything else to be sitting in a hallway somewhere waiting for a judge to become available because something else ahead of you has taken longer than expected. Well, those are examples of expense that you have in the traditional system that really can't be avoided, but that don't really do anything to advance a resolution of the real issues involved in the case. In a collaborative context, you're expending resources by comparison a lot more on things which directly advance you to a point where your issues are resolved. And the parties, as Jan noted earlier, have got a lot more direct participation and control over what happens and what doesn't. So the experience has been that the cost for people tends to be reduced, and in some cases significantly reduced, versus what would happen in a traditional court system type case.
But Jan, each of those parties you kind of put out linear would also charge their regular professional fee within the collaborative process, just like Mark would as the attorney part of the process. Is that correct?
The financial specialist and a coach or the family ambassador would. And when a mental health professional is involved, it is a flat hourly rate for most of us involved. We do not bill insurance. And part of that is again, protection of a person's rights. Because if it is going to go through and be charged under their insurance, it's not psychotherapy. And if they wanted to utilize their insurance, they would then need to be given a diagnosis. And they're not ill. They're going through one of the most difficult times of their life. And it's crazy making, but they're not crazy. They're not ill. And so that's why it's very separate from actual psychotherapy. And I want clients to be fully aware of that. So again, there is a flat hourly rate rather than billing it under their insurance. And quite honestly, maybe this I'm going to get on my soapbox, I'm real concerned where our health industry is going and where healthcare is going in America. And just within the last couple of weeks, calling up to try to get authorization for clients to come in. One was being outsourced to Jamaica, and I had two cases where they were being outsourced to India. So somebody over in India in a little cubicle, or somebody over in Jamaica in a little cubicle, was making some very, very important decisions about somebody here in the Midwest, going through a very difficult time of their life, just wanting to come in and talk to somebody. And so that's why I say that's what's nice about this is it's not run through your insurance. It's not in the big computer in the sky. There's no diagnosis that you're ill or anything.
Sure.
You're going through a difficult time.
And the concept, really, not to interrupt,
go ahead. No.
the concept with the way that the collaborative process is set up, particularly for family law cases, recognizes the reality of these kind of cases. The reality is that, yes, there's a lot of what goes on in a divorce case that's about dollars, it's about logical issues, it's about rationality. But the truth is there's also a tremendous amount of emotionality and stress and difficulty and fear and anxiety and competing values and conflict, and to ignore that really doesn't, not only does it disservice to the clients, but it really in the long run ends up being more expensive to them. And I'll give you an example. It's understandable for people to be concerned about cost. I would be if I were the client, and that's perfectly legitimate. And you might say, well, if we involve someone like Jan or Arlie Albrecht or some of the other professionals that we have that do coaching, that's going to cost me more money because now I've got another professional involved.
I've been thinking that through the show, just that, you know, you got different parts. Go ahead, I'm sorry.
My response to that is that oftentimes, in my experience for 17 years doing divorce and family law, people will lean on me as their lawyer for things that they would be much better served by talking with Jan about. Jan's hourly rate for this kind of work is probably half what mine is. So when we talk about cost, the way I look at it, and this I think is absolutely objectively true, if by working with Jan and going for a few sessions, a client might spend $500, let's just say, okay? But if we can reduce the number of meetings in their case that we need to have in order to get to a complete resolution from 7 down to 4, they're saving an awful lot more in terms of my fees and other costs than they would be paying by having the help that they really need from Jan. And as much as I care about my clients and I want to help them, the fact is I'm not trained to deal with the kinds of things that Jan is trained to do, nor am I trained to deal with complex and difficult financial matters, which Benita Graff or other financial specialists that we work with are trained to do. So it's about efficiency ultimately. Yes, you're paying more people, but the reality is if we can make the case work, and the vast majority of the time we are able to make it work, your overall cost is actually less.
Sounds like an adult wraparound program. You know, you do that with kids, where you troubled kids, you get different people to help them for different things. That explains it. I think that.
Well, who makes the determination as to, say a couple comes in and they are uncoupling, who makes the determination if they just need legal assistance or if they need your help as a marriage and family counselor or a therapist, and then the financial person? Who makes that, or is it just a given? Is it just automatic that if that's their situation, they have to have all 3 professionals involved?
It's not automatic. It is a decision ultimately that the parties make with the help of their attorneys. And we make those decisions really based on the circumstances of each case.
Okay.
I mean, if it's a case in which additional help or expertise is felt to be necessary after we review what's going on, then that's something that would be talked about and mutually agreed upon before we embark on the collaborative process.
Okay.
I mean, my feeling would be that the other professional disciplines, the financial specialist, the coach, a child specialist, if we're going to use a separate person for it, they would always be helpful. They would always be desirable. But it's kind of a Midwestern ethic that we have, that we tend to be more conservative in terms of spending money, and that's part of what's helped develop this process where we evaluate that on a case-by-case basis, and I think that makes sense.
Okay. Uncouplings, you folks have said, is one of the main things that you're seeing. One of the more popular things, if you will. And landlord-tenant things, you mentioned, is pretty high up there as far as things that people tend to mediate. Are there issues or disputes that a collaborative process such as this would not be able to handle, or is there something that would not be suitable for a collaborative process?
I'm going to jump in here if you don't mind. And
if
there's domestic violence or if there is a drug alcohol issue, yet on the other hand, sometimes it is the collaborative process that gives, in a domestic violence situation, may help the person develop some skills and help empower that person. and making sure that they're safe. And maybe helping to coach them to have a voice when maybe they haven't had a voice in the relationship before that. I guess that's sometimes what I see our role as a coach, is that maybe we're helping a person develop some skills to communicate more effectively, to resolve conflict more effectively, and maybe give them some skills and some education that they may not have had before. And I oftentimes say, your relationship may not have always been the greatest, but we're going to help you have a good divorce.
Okay.
Or have a good relationship afterwards, and especially when there's children involved. When it comes to, as I said earlier, about drug alcohol issues, again, I've seen it work, the collaborative process work very effectively in regards to this. And part of it is the timing of appointments. Part of it is, again, empowering all the parties involved as to when to have those meetings, and maybe when it's time to say, you know, we've done enough for today, let's reschedule. So again, those are two situations that you have to tread very carefully.
Sure. Things like workers' comp cases, personal injury cases, things like that, that's not something that could be handled through a process like this, is it? Or is it?
It could be. It has not become popular or commonplace to resolve those kinds of legal issues using the collaborative process, although it could. I'm aware of some pilot programs and so forth where they've explored the use of the collaborative process to resolve issues like that, and they've had some success with it, but it hasn't gained widespread acceptance, as has been true in the divorce and family law area. Generally speaking, I mean, in order for the collaborative process to really work, as we talked about before, people have to be genuinely motivated to want to use it. And so the most obvious example where that's kind of true by virtue of the built-in facts is when people have some reason to either want or need to have a continuing relationship after the dispute in question has been resolved. So if you've got a partnership dispute, you've got a landlord-tenant problem, you've got boundary line property owners having some type of a disagreement about a fence or some shrubbery or whatever the case might be, if there's a need or a desire to continue to have a relationship and to try to make it as reasonably positive as possible, that's kind of a built-in incentive for people to want to resolve it in a way that's harmonious.
How do you start this? Could a person go to either of you, or is there a one-place starting point where if some viewer watches, say, you know, I'd like to, how do we proceed, or how would they proceed with that? Is it, they have to go to one person, or either of you, or all of any of you in your group? How do we do that?
Again, they can typically, if somebody comes to me seeking out information, seeking some guidance, and as well as maybe a sounding board, I'll give them and present them information, and then typically refer them to one of the attorneys.
Okay.
Yeah.
So they could contact any of our members, and any of our members would be happy to provide information, help empower them to make a good decision.
And no fee charge, just an information sort of thing that explains the collaborative process?
They would have to contact each individual professional. I can say in my case, if somebody wanted to talk with me either on the telephone or in an in-person consultation, I don't charge at all, and I'd be happy to do that. If people are wanting more information and don't even want to necessarily have a meeting or a discussion, they can go on our website as well and get some at least general information that way.
And that's a key, and I want to again highlight the website because, you know, many times people in privacy of their home in the middle of the night or early morning hours can always go there and take a look at it and get some information and go from there.
Yeah, good point.
And I believe we've been putting the website address up during the course of the show. So how wide of an area does your organization cover? Because I know on your website you've got a lot of different counties listed.
It's pretty much throughout northeast Wisconsin. I don't have all the counties memorized necessarily, but generally speaking, it's going to be you know, the northeast part of the state, extending probably down as far as Fond du Lac and then up to the border with the UP and over to the lake.
Oh, you do go as far as the UP. Okay,
Mm-hmm.
all right. So it does go beyond Brown County then?
Mm-hmm.
Okay.
Yes.
Okay, all right. What about someone, Dan asked a good question about how someone, gets started with this process, who they contact. What about another professional out there?
Good
Whether
point.
mental health professional, attorney, financial advisor. What if they're interested in becoming a member of this collaborative? What would they do? Who would they contact? Would they take the same steps?
I think they could. I mean, there's really kind of a tremendous opportunity for people that are professionals that are interested in offering collaborative services. It has spread dramatically, tremendously, in a very short period of time, and it's not because there are billions of dollars in multinational corporations behind this movement. It's a grassroots movement because it meets a need that many people have that really hasn't effectively been met by any other process. And so it's really a wide open opportunity for professionals that are interested. Any of our members would be happy to speak with someone, an attorney, a mental health professional, a financial professional that's interested. Again, they can also get information on the website. And the website lists, we have roughly quarterly meetings which are throughout Northeast Wisconsin. And other professionals are more than welcome to come. You don't have to be a member to come to our meetings. And that's a terrific way to network and to meet other collaborative professionals and get more information.
And check it out. Along with the fact, too, we've just developed training in our area. And Mark's put together a wonderful training manual and putting together a CD that we can hand out to professionals that are wanting to take a look at it and kind of check us out. By all means, we're very approachable, and that's, again, with our membership, everybody is so approachable. And so by all means, give us a call.
Okay.
Yeah.
Well, you folks are here tonight talking about your collaborative, but I was noticing on your website you have a speakers bureau. Now, tell us a little bit about that and how that differs from this, or is it any different from this? Obviously, you don't have cameras all the time, but tell us a little bit about that, if you would.
Well, the Speakers Bureau, we're really just referencing the fact that a number of our members are really quite eager to go out and spread the word about this process. It's really something that many of us believe in. It's not just a way to make money, it's something that we believe in. It's an option that should have been available for people a lot sooner than what it has been. And now that it is available, we'd like people to at least know about it. The process of providing information to people so that they can make good decisions about what's best for them is not something that's always provided. And so the more information we can get out to people in the public to let them know, you do have choices. It's not a situation where you're on your own or you have to be in a litigation context. And so we're willing to certainly come to professional meetings, civic or charitable groups, or any other location where people are interested in hearing more about this. We've got members that are more than eager to come and to present a presentation to help provide some of that information.
And eager is a good word for it, because, as I said earlier, most of us who have been drawn to the collaborative process have been around for a while. We've seen the horse cases. We've seen the children caught in the middle. We have seen people who have been injured and damaged. And this is just a kinder and a gentler way, because most people know somebody who's gone through a divorce or is contemplating it. And so, I mean, it's affecting a number of people out there, and so by all means we're more than eager to go out and give a talk, give a presentation. We've got a PowerPoint presentation. As I said, Mark's put together a wonderful training manual. However we can be of help.
Well, I just think it sounds like a wonderful option, because as you mentioned early on, Jan, people, I think, traditionally just think of, okay, if I'm going to get a divorce or there's going to be a separation, well, in the first place, I'm sure that a lot of couples who aren't married probably don't know that they have any rights, and so that's good to know just right off the bat. But in a situation where there is a divorce per se, they either think of, okay, we do it ourselves, which is the pro se method, or we have to go and hire an attorney, and there's going to be all this squabbling, and if there's children involved, then we've got to have a guardian ad litem, and my God, the costs are going to mount. And this does give them options and puts more control in their hands. So I think it sounds like a wonderful approach.
And thank you. Thank you for this opportunity to come and to get that information out there, because as we said earlier, most people only see it as, you know, one of two choices. And, you know, as I said, about 67% of the couples that go through pro se would have chosen another way had they known of them. They just didn't know of the different options out there, along with the fact, too, with the professionals involved, those professionals are going to be able to point some things out. We just went through tax season just a few months ago, and I had one client that the divorce was completed and had no idea how hard she was going to get hit with taxes. And again, you know, if been given that guidance and direction, would have had a heads up, or maybe would have made some different decisions, or what have you. And so that's where the professionals can give you those heads up, or give you those, you know, ideas of be prepared, and stuff. So,
About how busy have you folks been since you've started this collaborative?
It kind of wanes. Sometimes it's real busy. I think certain times of the year may be busier than others, at least from this end, that sometimes couples will stay together to get through a holiday or get the kids launched into the school or what have you. So it kind of varies.
So it's becoming a little more popular with people. People are starting to hear more about you and know more of what you do.
I would say it's growing. It's when the process first came to Wisconsin and first came to the Fox Valley, I would never have clients that would know about the process. It would only be by my telling them about it that they would know about it. And I'm now having people that are coming into my office that I have heard about the collaborative process and want to learn more about it. And of course, I'm happy to meet with them and to provide that information. But it is growing. It's under the radar yet, I think, at this point. There's a lot of people still who haven't heard about it or don't know about it, but it continues to grow, and every indication is that it's going to continue in that sense. So, again, you know, we thank you for the opportunity to come and talk about the process.
We appreciate it very much too. And on your website also, you have links to other places on the internet that explain to people more about the collaborative process, kind of how it got its beginnings and that kind of thing. So a lot of information out there. Thank you both very much for being here.
Very much.
It's
Very
been a real pleasure.
informative.
And good luck with this.
Thank
I do
you.
think it sounds like a good option. So Dan, thank you.
Thank you.
Thanks to the crew.
Yep.
And of course, thanks to you all at home. We'll see you next time. Until then, take good care. Keep your eye on us. We've got our eye on Oshkosh.